children that they had ranges in age of 7 to 14, and I'm left there literally scratching my head. I'm just amazed at how wonderfully these two people communicate. It was almost unbelievable.
And you know, looking at that couple post-divorce, they're probably going to raise those children in a very fine fashion.
Yeah.
Right?
In fact, at the end of the case, I said, "I wish you good luck. I commend you for what you're doing." You know, and I half-jokingly said, "Are you available to provide therapy or intervention to other couples in matrimonial cases?"
Let's look at the other side of that, and that's the domestic violence side, where there's some sort of abuse between the parents or abuse between a parent and a child. How does that impact on custody?
It is a devastating factor in terms of the parent-child relationship, because in the vast majority of cases where there are final restraining orders in effect, number one, the statute says that there's a presumption that the defendant who is on the receiving end of a final restraining order shall not have custody of the children. Now, that's a presumption that can be overcome and rebutted if the facts warrant, but it's a pretty big hurdle that the defendant has to overcome. It also has a very dramatic and significant effect on the defendant. More often it's the father, not the mother, but there are cases where the mother is a defendant in a domestic violence case. But statistically, it's probably 75 to 80% or more that the defendant's the father, and the father, as a result of the fact and reality there's a final restraining order in effect, is now very limited and prescribed in the extent to which he is able to communicate, A, with the plaintiff mother, and B, with the children. And of course that will vary depending on their ages, but if you're dealing with children of the ages of, let's say, 3 or 4 all the way up through the preteens or early teens, it's going to have a significant effect. Now, there are exceptions where the parties, for example, if the plaintiff speaks up and says, "Well, Judge, I think that there should be no problem if the defendant has telephone or email communication or text communication with the children. I don't have a problem with that. In those cases, I will allow the defendant to have limited prescribed communication with the children." And sometimes, occasionally, the plaintiff affirmatively requests, and the court will then allow limited contact by phone or by email, not direct face-to-face contact, but direct contact by phone and email or text messaging with the plaintiff to discuss issues relating to health, education, welfare of the children.
Judge, let's talk about one of the other factors, and that's the preference of the child. Mm-hmm. When, at what age, do you think a child can express a preference that you're willing to give a lot of weight to?
Well, obviously, the older the child, the more likely I'm going to give weight to what the child has to say. There is no magic age. The statute, I think, speaks in terms of the court giving significant weight to a child's point of view starting with age 14, but that's not mandatory. It's basically a strong suggestion that the court can take or not take.
Yeah, the children don't make the decisions.
They do not make the decisions. They certainly have a voice, and that voice will be heard depending on their age, their level of maturity, and the court's assessment as to whether or not what I hear from the child is legitimate, bona fide, and unadulterated by virtue of contact or pressure from one or both parents.
I mean, no coaching.
Right, exactly.
Right? Now, do you interview the children in all cases, or in the majority of the cases?
We interview the children when we're asked to. In the vast majority of cases, there's a court rule that essentially says to the court, says to the family court judge that you shall interview the children when it's appropriate, depending on their age. I'm not going to interview a 4-year-old. I'm not going to interview a 5-year-old. But I have interviewed children as young as 9 and as, of course, as old as 17, 17 and a half.
Now that interview is in your chambers.
That takes place
in camera, they call it, right?
In camera, which is a fancy word for in chambers. It's not in the public courtroom. It's recorded so that there is a record, so that if there is a ongoing custody, if the case is not resolved and goes to full hearing, plenary hearing, the record of that interview is available for the parties and the attorneys to have and be able to refer to. But otherwise, it's confidential, and the the public at large may not obtain a copy of that record or that transcript.
Now, and one of the factors is the home environment, the
Right.
environment of each of their homes. That a big factor for you?
Well, it is a big factor, but there have been relatively few cases where the home environment has been a negative. The vast majority of cases that I've seen over the last 5 years, the home environment is at least acceptable and not, it doesn't really play out as a major factor in most cases.
The proximity of homes to one another.
That's a big factor. If both parents are in the same town or same school district, that's a factor that I look to try to maximize parenting time by both parents. Obviously, if they haven't been able to agree, then it comes to the court to make a decision, because the child or the children are in the same school district, and the closer the better in terms of being able to share time. If they're in the same neighborhood or same section of the town, obviously that's a big bonus to make shared or joint residential or physical custody workable.
Now, what about in families where there are multiple children and one child wants to go with one parent and the other with another parent?
Mm-hmm.
How do you view that, separating children? Does that happen much?
It does happen. Fortunately, it doesn't happen a lot in those cases where the parents or the children ask for that type of relief. Those are cases that more strongly cry out for the children to be interviewed to try to get an understanding as to what's happening, what are the dynamics in the family as to why this is being sought by either the parents or the child or the children involved, because I think there is a policy in the law that says, and I adhere to it, that barring exceptional circumstances, really do not like to see the children split up, because of it obviously is going to have an impact on the bonding relationship and future relationship between the children.
I've had several cases where there are two children, let's say, and one, let's say it's a teenage son bonding with the dad, and a young girl bonding with the mom.
Right.
And that's, I guess, more typical than not. And they don't want to, one child does not want to live with the other. And so you start out with everybody kind of saying, that's the way it should be. And in those cases, what